Well, the defense in the Lori Vallow murder trial in Idaho rests its case without calling a single witness, not even the so-called Doomsday mom herself, Lori Vallow, who decided not to testify in her own defense. Closing arguments will now begin tomorrow. The judge and the attorneys are going to be going over jury instructions today. Vallow faces charges of first-degree murder in the deaths of her 7-year-old son, JJ, and her 16-year-old daughter, Tylee, in September of 2019. She is also charged with conspiracy in the death of her husband, Chad Daybell's late wife, Tammy. If Lori Vallow is convicted, she faces the rest of her life in prison. She was deemed competent to stand trial in this case. There was some ambiguity at first on that. I want to bring in former FBI special agent and attorney Stuart Kaplan. And the reason I bring that up is because if you have been following this trial, it's wild, and it's wildly sad, the details of it, and confusing probably for the jury as they've been taking meticulous notes. I'm curious, we wondered what the defense would do. Was rest their case without calling any witnesses on your bingo card?
Well, look, and good morning, Marnie. I mean, first of all, really the only witness would be Lori Vallow herself, and I think that has been certainly proven that she would not make a good witness. In fact, if you think about the procedural history of this case, there was a certain time that, in fact, her competency was being challenged with respect to her even being able to stand trial, and then that hurdle was overcome. I think if you recall, during the Alex Murdaugh case, I questioned the decision-making of putting him on the stand because, just quite frankly, I think he had no jury appeal. I think in this case, Lori Vallow would be her worst enemy. I think also from my perspective as being an attorney, the strategy here is, quote unquote, there is no direct evidence, meaning no direct evidence that puts Lori Vallow as the responsible party being accused of killing her 2 children. And I think they're basically banking on coming in during their closing arguments and saying that all of this mumbo jumbo is circumstantial. It doesn't add up, and to equate that their client, Lori Vallow, is in fact the responsible person to have taken the life of her 2 kids.
How does the jury perceive the move from the defense not to call any witnesses to rest the case?
And that's a great question, Marnie, and I'm often involved in that type of decision-making and that strategy. You know, you take a step back and you say whether or not the jury may say, well, the defendants are taking a position like, hey, this is not a big deal. There wasn't anything here. And what are we doing here? This has just been a charade and a big waste of time. And the prosecutor, has just been kind of throwing up, innuendos and rumors, but nothing really connects the dots. I think, though, in this case, and certainly with respect to the credibility of some of the witnesses that were brought in on behalf of the prosecution, and in particular the FBI agent who went through very methodically with respect to the phone data. And then, of course, there's an abundance of forensic DNA evidence that does, in fact, identify hair samples and DNA on a shovel. I think there's overwhelming amount of circumstantial evidence that will ultimately lead to her conviction. I will also applaud the prosecutor. There are sometimes that a prosecutor can over-try their case, but in this particular case, I think they have teed it up perfectly.
There has been, Stuart, I agree with you, a lot of compelling evidence that has been put forth to this jury. And the prosecution's last witness was Nicholas Edwards, a lead investigator for the Idaho Attorney General's office. He was involved in the search at Chad Daybell's property, and he described what it was like when he found 7-year-old JJ Vallow's body in a shallow grave. I want to play his piece of testimony for folks at home.
It exposed some rocks. We were using small tools, brushes. Once those rocks were exposed, we removed the rocks. There was more dirt. There were boards, 2 boards. And we removed the boards. There was dirt. And then exposed to my right, as I was kneeling down on my hands, there was what appeared to be the shape of maybe a head in a black bag. My experience after that was this flood of emotion that we found him, that we probably found JJ, and thoughts of my own son that was the same age.
And And just to add to that testimony, and it was emotional for that agent to come upon that. It would be for anyone. We now know that JJ was in red pajamas. He was wrapped in a plastic bag over his head. He was duct taped. He tried to fight back and save his own life. My question to you is, as the jury is instructed now from the judge on how to handle deliberations, they will be told to keep emotion out of it. I don't know, as a human being, how you hear the details of finding that little boy on that property and how his life was taken, that you can take emotion out of it.
So, Marnie, with that's a fair statement, and they will be instructed, obviously, to not render a decision based upon emotion. But the judge will also instruct them and remind them that they did not leave their common sense outside the courtroom door. And with that being said, you will have a prosecutor who will continue to hammer home all of the circumstantial evidence with respect to just taking a common sense approach. And by way of example, Marnie, this same defendant had a recorded conversation with a friend where she challenged or questioned why her friend had volunteered that Lori Vallow had been the last person to have been with her son at that particular time. And that's a perfect example. Devastating evidence. It's circumstantial. It doesn't necessarily mean that, you know, if Lori Vallow was last, or the child was last with her mother, with his mother, but still, again, circumstantially, it's certainly when you start to, connect the dots, leaving the emotion out of it, I think from a common sense approach, and of course, with respect to the charge of circumstantial evidence, there is no doubt, beyond a reasonable doubt, they will come back and render a guilty verdict in this case.
All right, those deliberations start tomorrow, and once that verdict comes down, just a reminder for folks at home, the judge has agreed to allow the verdict to be read live streamed on the court's YouTube channel. We will have that for you here on News Nation. Stuart Kaplan, as always, thank you.